So are there any forms that you guys specifically want to look at?
It's whatever's changed, right? You guys have, has the offer to purchase changed?
Not yet. No, I think it is going to. At least that's what Jason was saying.
Jason gone?
He's gone. He's actually gone to Keller Williams Chapel Hill. Well, I know yesterday when we were in another session, there was a newer agent that was wanting to, they're doing a buyer consultation on Friday and they were looking at wanting to do the buyer forms. This week's actually designed or set up to do all the miscellaneous forms other than, so they do the buyer forms first week, seller forms second week, offer to purchase third week. I believe is the schedule, and the fourth week is supposed to be everything else. So, we could do, if the one agent shows up, and we'll probably do some buyer stuff, buyer agent forms, but if you have any of those other forms you want to talk about, that's
We're going through buyers.
today. Okay. And that one, of course, buyer agency did change recently, but not
2024.
right, I guess like October. Yeah. So,
And I don't know if you can do this or not, but like commercial stuff.
Mhm.
You know how they have.
why my TVs are on.
You know, commercial stuff, they have. Tenant and buyer. Don't have to do both, right?
Yeah,
On commercial.
I mean, there's certain documents that are that you can use in commercial computing environments.
I'm saying that they got one document that you can use. At one time, that includes the tenant and the buyer. And my question was,
Not today, we did one yesterday
My-
for the lease.
my thing is on the. So we're helping the tenant, not necessarily the buyer, so. If we don't fill out the buyer information, we're okay, right?
It's higher than 10, so you should be fine. What are you talking about, like compensation for that buyer or that tenant?
Correct.
So how are you being compensated, or are you?
We're being compensated by the seller, not the seller, but the
I
tenant,
see.
yeah, the receiver.
The listing party on this side. So you would still put in your buyer agency agreement, because it has to have something in that compensation. So whatever the agreement or whatever the compensation being offered for a particular property, you can always put what you're gonna charge and then reduce it if need be later. You know, if it's not as much. So let's say you're let's say that the tenant amount is $2,000. You can put that in. Right? So you're on the buyer's tenant agreement. I have to look at, the commercial. Or it should be there.
mean, we're going after the seller or leasing for that kind of stuff.
Right, not necessarily the tenant.
Correct.
Right.
But I just wanted to know if they're not, see, they didn't want to fill it out because they're not buyers. for tenants. So that was my concern, that because I didn't fill it out. And I didn't know what she would do. I know what Jason would have done, but I don't- Jason would have kicked it back to me because it wasn't completed.
Yeah, if you don't have complications, there would be.
No, on that, yeah.
Because there has to be something, I mean, that's the whole reason for the agency agreement.
And I get that, but if they're not buyers, they don't want to fill it out.
So not one just for tenants, or does it say buyers and tenants?
Buyers and,
It's on the same.
Yeah.
I thought it was. So-
yeah, on the same document.
Yeah. You just have to disclose whatever, you know.
I put it.
Would be applicable, yeah, getting paid for the term.
No, if you're a buyer, it's not applicable. Because they're not buyers.
Correct, if the documents require tenant.
Knowledge slash school.
It's
So it's-
separate line.
Did Jason and Scott, did he go over there to be BIC or is he a broker over there?
Um,
You know?
that has not come out completely. My guess is he went over there to be the BIC. I know Leah Cole and Chloe recruited.
Is Chloe over there now?
She's over there.
Really?
But Leah coached her as well. They're not supposed to be doing that. They're not, Keller Williams aren't supposed to be coaching from other Keller Williams offices. And that's what happened with both of them. So
Both of them.
Chloe, well, there's been actually a few. Chloe and somebody that went with Chloe, Shauna, Shauna Poole, I think, and then now Jason. Now, we didn't, I don't know how we know they poached Chloe. But, and that's Leah doing that. She used to be our bid, so I'm not sure what's going on there. Let me see if there's anybody that's joined Zoom. Okay, there are, Joanna. Joanna, can you hear us?
Hello, hello. Yes, I can. Can you hear me?
Maybe I can't hear you because it's on my end. Hang on just a second. Okay, so you can hear us. All right, good. Is there anything, Joanna, is there any document specific that you want to make sure we cover today? Buyers, okay.
No. Are you teaching today?
I was elected. Karen would have been, but she's in Marathon this week
It's Marathon.
down at the Keys.
What?
She's down in the Florida Keys.
Oh, Karen. I
Yeah,
thought you said Karen.
no, she's on duty this afternoon. Just a login.
Hmm. You can sign in on Zoom if you want. Yeah. Okay.
It's only gonna be here for 30 minutes, but
Yeah, and the way I had to get into it is I went to the link that was on the calendar for next week
Yes.
through Zoom.
Oh,
For the PB and J, so if you have a link for the PB and J, go to that.
yeah, this one. Or is that the ones that figure today?
Try that, that should get you that. Well, bear with me for just a moment. I'm trying to get the documents.
Progress.
There you go.
Showing what? I don't know how to answer it. I can't even get into it. Are you able to reset me? Yeah, if you could do that, I'm just trying to work on this. Okay.
For some reason, I'm having a hard time getting it to turn on here in the room. All right, so while I'm waiting for the system up here to reset, I'm not able to get it up on the TVs right now. Looking at the buyer agency agreement. Of course, it recently changed to 3 pages, right? And I mean, they've really condensed it. If you've looked at it, it really, I think it makes sense the way it is now. But they have moved some things around. And we have to be really specific about where the fees are coming from and that kind of thing with the buyer or a tenant. So starting at the top of the buyer agency agreement, of course, does everyone understand the WWRA? I know the ones in the room do. Joanna, you understand WWRA and the purpose of it, correct? And I know you're driving, so if you can unmute, that would be best. Hey, got it. Okay, we're up and running in the room. So, yeah, go away. Is that same thing on those TVs?
Yes.
And see, it doesn't show on here at all. It's just showing on the TVs. There we go. Okay. All right, so starting at the top of the buyer agency agreement, of course, we have the parties that are involved. So you have your buyer or buyers. And then, as we know, they hire the firm. So the firm's name goes on that second line. The services that will be provided, firm will assist buyer in locating property or locating and buying the following real property. Now, you could put in there properties in Alamance County. I know before there was a checkbox and then you had to, whether it's residential or whatever. Here, just type it in. It just put it in there, whatever they're looking for. Commercial property in North Carolina or whatever area that you serve. Buyer disclosure, buyer makes the following disclosure and agrees to update them immediately if any changes occur. First one is buyer has or has not signed a document with another real estate agent or firm. If buyer has signed a document with another firm, for example, a document signed in order to tour a property, buyer agrees to give firm the agent's contact information and so that we can confirm as our firm, the ability to be able to service this buyer, right? Then buyer is not is or is not working with a relocation company, and buyer has or has not received sample copies of the offer to purchase and professional services disclosure form. I'm surprised they don't actually number the forms there, but they at least name them. Term of the agreement. This is your expiration date. Though they're numbered, they're just not numbered in this section. They just say purchase contract and professional services disclosure and they don't even call it the offer to purchase and contract. They call it purchase contract. So, kind of abbreviated to fit it in there, I guess. I'm not sure. Term of the agreement, it has to have an expiration date. Okay, if it doesn't have an expiration date, you have an invalid contract. So make sure whatever that expiration date is to put it in there. Fee for services. If your business practice is to charge a retainer fee, this actually says that it is a non-refundable retainer fee. It used to be that you checked a box that said either it's refundable or not. And here it says it's not, if you charge one. If you do not, just don't check the box. The next box, percentage of the gross sales price. This is what our firm expects to receive from that transaction. All right, so if it's someone that's looking at commercial property, and we have a couple of commercial agents in the office, in the room, it might be 5% if that's what you're looking to get, right? It could be whatever your number is. I know that office policy for residential properties is as little as a total of 5% or 2.5% our side. Okay, so you could put the 2.5 there. Whatever your fee is goes there in that second line. If there's a flat fee that they've agreed to do as a buyer, then that's where the next line would be a flat fee. And then if it's anything other than one of those three things, you would put it on the fourth line, an other specific amount. So you want to spell it out as to what that is. Then it goes into how that fee is earned. And basically states here that except for any non-refundable retainer, the fee in this section will be earned by the firm when the buyer enters into a written contract during the term of this agreement to buy real property as described in section 1. The fee, so it's important to make sure that whatever they're buying is filled out up here in section 1 under services provided, and it's not something that's not written in there. So if you were very specific and you said, okay, they're just going to look for a property in Alamance County, and then they go under contract on one in Guilford County, technically that buyer would not be responsible to pay you for that. So make sure you cover all the bases when you go into that for that services provided. Selling or listing firm assistance, firm may seek compensation from the seller or listing firm to pay some or all of the fee in this agreement. However, buyer understands that neither a seller nor a listing firm has a duty to pay firm's fee. It's really getting back down to the lawsuit and what happened with this paragraph, because the disclosure and the understanding of where the fee was coming from was the big issue, or one of the big issues with the lawsuit. Mutual termination required. If buyer hires another buyer agent or firm while this agreement is in effect, buyer will remain liable to pay for any earned fee in this section. So it's important that they understand that they cannot enter into another buyer agency agreement with someone and not owe you the fee. Protection period. This is where you would put that number of days. I do 60, depending on the particular buyer. But typically what I will put is a 60-day period after this agreement expires, that if they go back to buy a property that was introduced to them by me, they would owe me the fee. Paragraph number 5, negotiable fee and additional compensation. Buyer understands that the amount, format, or rate of real estate compensation is not fixed by law, but is set by each broker or firm individually and is fully negotiable. That's in every one of our new agency agreements. Firm may not receive compensation for services from any source that exceeds the amount or rate agreed to herein with buyer. Any questions about that?
I have a question.
Okay,
The residential property disclosure.
Yeah.
If you have a seller who's selling their house, are they required to do that without an agent?
they are. Yeah. Yeah, but and keep in mind, there's 7 exemptions to that. If it was a family transfer, when they transferred it from, let's say it's an heir situation or before that person passes, they transfer ownership to a new owner and it's a family member. They don't have to do it in that situation. But the new owner would have to if they just put it on the open market. And so very rarely do we run into where that it's exempt. Of course, new construction is exempt from the RPD. Okay, but yeah, that's required by law. Actually, the MOG and the lead-based paint are all state and national forms, state and or national, I should say. Okay. So if going back to paragraph 5 on the bottom of page 1 of the buyer agency agreement, if you were to, let's say that your fee agreement in the buyer agency agreement was 3%, and your buyer decides they want to go look at new construction, and that new construction site offers the 3% plus a $5,000 bonus to the agent. We can't accept that $5,000 bonus without their approval. So once we find that out, if they're okay with letting you take that and earn that, the buyer, then the buyer has to sign Form 770 to agree that it's okay that you accept that $5,000 bonus. Okay. And same thing with, if, let's say your buyer agency agreement said 2.5 and the compensation was 3, they would also have to sign off on that, and they don't have to. They can leave it right where it is per the contract, even though they're not the one directly paying you. Okay. Does that make sense?
Yeah.
Okay. I know it kind of sucks, but it's what it is. Dual agency. So I know Terry and Roger understand dual agency. Ada and Joanna, how are you on dual agency? If you don't mind answering, and I know if you're driving, don't answer if you don't feel comfortable. However, it would be helpful if I know what you know about dual agency.
Can you hear me? Hello, hello? Can you hear me? No. No, hello?
Ryan, I'm not sure if you're talking, why I'm not hearing you. Hang on. Okay, Joanna, say something again for me.
Hello, hello?
Ah, there you are. Okay, we can hear you now.
There I am. Okay, so I think I'm okay with dual agency. That just means that I could work on it and another person, I guess, in the Keller Williams family would be able to also be on the other side of that transaction, right?
That's correct. And when you say Keller Williams family, that's Keller Williams Central, okay?
Keller
So
Williams.
if you were to deal with Keller Williams 1 or Keller Williams, what's the one out of Raleigh? Elite, if you were to have a transaction with one of those other firms, then it would not be a dual agent situation. It's only if it's a Keller Williams Central listing that you're going to be writing an offer on for your buyer. Okay,
Oh, so it's only like the specific facility.
correct. So
Okay.
now our Hillsborough agents are also included in our firm, even though they're in a different location. They are still our firm. They're under the same operating broker. Okay. The best way to know to rather really distinguish that is when you're writing the offer and you check that agent's firm license number so it can go on the offer to purchase. If it matches ours, the C21388, then it is in our firm and we would be a dual agent. Okay.
Okay.
So yeah, you're right. It's within the Keller Williams Central family. It would be a dual agent situation. Okay. And under that dual agency, they need to understand if you're not representing them as a designated dual agent, that the agency, you can't really advise them or guide them on what to offer or how to negotiate or anything like that. You're basically a middle person pushing paper. Okay. That's why I feel like it's best that you be a designated dual agent. However, not everybody practices that way, and that's okay. That's up to each individual how they want to do that. Okay.
And I'm sorry, but I think I missed some of it because I couldn't hear. I don't know if it was because of my car or what. But could you go over really quickly just about the retainer fee again?
Okay.
Mhm.
Go ahead. Yeah, you want to make another comment or
Oh,
question?
I was just gonna ask. I think so. It's okay for us to ask for a retainer fee, but we have to inform Keller Williams about it first. I don't know. I couldn't really hear, so.
Okay, so if it's regardless, the retainer fee has to go through the office. So yes, you would notify the office about that and what it is for. Okay. If the retainer fee is over $500, it is subject to the market center splits. If it's under $500, it's not subject to the market center splits. Okay. So let's say you had $1,000 retainer fee, it's non-refundable. They make the check payable to Keller Williams Central. Keller Williams Central will then cut you a check for whatever your share of that would be, which should be the 80%. I say that it's probably the 74% because you still have to pay royalty on it as well. Okay. And since it's non-refundable, that will be a part of the total compensation when you close. Okay, so it would come off of that amount at the end. Okay. Did that answer your question, Joanna?
Yes, it did. It did.
Okay. Most people are not asking for retainer fees. I do know of one particular agent that we have in Keller Williams Central from Hillsborough that does a retainer fee on both buyers and sellers. So, and she doesn't have a problem getting it. I don't know that all buyers would be willing to do it, or many buyers would be willing to pay a non-refundable. So at the top of page 2, it goes into that dual and designated agency description. Again, as a dual agent, straight dual, not designated dual, you would not be able to advise that client. However, material facts must be disclosed. So anything that you know of that is a material fact must be disclosed to all parties. As a designated agent, you get all of those fiduciary duties back for your client. So you're able to give them confidential information if you hear of anything. And then right after the explanation of it at the top of page 2, you go into the authorizing of dual and designated agency. This is where it can get a little bit confusing. I think they cleared it up better than the last buyer agency agreement, but it's still, I think some people don't quite understand this part. So the first line under that paragraph of 6B says, and they would initial, firm may not act as a dual agent in a transaction involving a buyer. So if they were to say, no, I don't want you to be a dual agent, that limits you from being able to even show or write an offer on a Keller Williams Central property. Okay, so it is best that they select dual agency, whether they select designated or not. Okay, reason being is we have the most number of agents, and our market share is much higher than the second or anyone else in line. Okay, so we have the most listings out of anybody. So they would, in my opinion, they would want to initial that second line under 6B that says that firm may act as a dual agent in a transaction involving a buyer. The next section is with regard to the designated agent. And it goes into, if firm may act as a dual agent, then buyer should only initial one of these lines. The first one is buyer does authorize the same agent to represent both the buyer and seller in dual agency. So that's where they're saying, yes, you can be that dual agent and just be a paper pusher if need be. The second line is buyer does not authorize the same agent to represent both buyer and seller in dual agency. And the third box is buyer does not authorize the same agent to represent the buyer and seller in dual agency and directs firm to practice designated dual agency. If a buyer directs firm to practice designated dual agency, the firm will practice designated dual agency unless it's not allowed under North Carolina law, which it is. Buyer authorizes firm in writing to practice dual agency only. So if they were to put it in writing that you're just going to be a dual agent, then that's the case. So here, if they allow you to be the designated dual, can somebody tell me which line they would, 1, 2, or 3 on that bottom part, which one would they initial? And Joanna and Ada, if you're talking,
Can't see
you're
it
muted.
there.
I think they're both muted. Yeah. So what do you guys think?
See it that well.
Oh, I don't know if I can zoom in on that. Does that help?
Yes.
Okay.
So you wanna know,
Yeah, so there's 5 lines basically under 6B. Those bottom 3, if you were to number them 1, 2, and 3, top to bottom, which one do you think would be the one that they would initial if they authorize you to be a designated agent? Well, that's if they don't. In essence, yes. But it goes on to say in the last one that if the buyer directs firm to practice designated dual, the firm will practice designated dual unless it's not allowed by law or the buyer has put in writing that it is not. So I believe the best one to do would be the third one. However, I do believe the first one could be signed and it would allow you to represent both. Okay. It's a little bit redundant in my opinion. So I think either one would fly. Actually, no. Buyer does not authorize the same agent to represent both buyers. So it would just be the first one. Terry, you're right. You're right. The first one would be the correct one.
Material facts, it goes back into that all material facts would have to be disclosed regardless if there's dual agency or not. And then if there's a waiver, they would have to put it in writing. They would have to say, okay, we understand that you're no longer being designated, that it's just to become, you're now going to be a dual agent. And that could happen, at some point in your transaction where they just say, okay, look, let's just put this thing together, right? Surveillance, photographs, and video. Buyer understands that some properties may have video, audio, and surveillance devices. Federal and state laws prohibit the recording of oral communication without consent. However, you gotta love however, right? However, video surveillance without consent may be permitted. Buyer may take photos or record video as long as the buyer does not intrude on the owner's reasonable expectation of privacy and the owner has not prohibited video or photography. Buyers should only record spaces in plain view. If buyer were to intrude on an owner's privacy, for example, if buyer were to take photos of a medicine cabinet or inside a desk drawer, then buyer may be subject to liability. Okay, so if you have a buyer that likes to take photos, then they need to be careful what they're taking photos of. And the last sentence in that, firm may not have control over pictures of video of a property that buyer may purchase. And accordingly, such information will not be removed from public display after buyer's purchase. It used to put in there that they weren't even able to put it out like on social media, that they looked at this great house. It doesn't say that anymore, so I'm kind of surprised at that. Here's your other professional advice paragraph 8. Buyer's advised to seek other professional advice regarding law, taxes, finances, insurance, surveying, wood destroying insects, all of those things, because we're not the professional in those areas. Any questions about that or anything so far? Okay. Inspection costs. Unless otherwise agreed, buyer must pay for all inspection costs and other professional services related to the purchasing of property, including all items in Section 8. This duty to pay will apply regardless of whether the buyer closes on a property. So that covers them or covers us, so that if they ordered a home inspection and they never paid for it, that home inspector don't come after us for that fee. That's why it's important if you give them 2 or 3 names of home inspectors to call or any of those other services, that they actually make the call to schedule that, or they go online to schedule it, not that we're the ones making the call. I know we like to do it. We like to help our clients, but it's much better if they do it. Okay. Confidentiality, firm will not disclose the price or terms on any offer by buyer to a competing party without express consent of the buyer. However, sellers may elect not to treat buyer's offer as confidential. Sellers may also elect not to disclose other offers and instruct their agent to keep that information confidential. So with that paragraph there, we're going to communicate our offer. Per the contract, it says that the other agent may share that confidential, the price and terms with another buyer. However, our code of ethics says you cannot. So code of ethics is more restrictive. And so it would override this if it came right down to it. The seller also may not disclose or may not elect to disclose whether there's other offers or not. I know in the past, it used to be that if we received multiple offers, we would just tell everybody, hey, we've got multiple offers, bring your best offer by whatever day, right? And then a few years ago, they decided that it needed to be approved by the seller that we are able to tell other agents that we have multiple offers. Any questions about that one? Wire fraud. Wire fraud is a big issue. This is just giving the buyer a warning that if they receive any correspondence, whether it's email, phone number, whatever, that they double and triple check to make sure that that information is correct and that they're wiring funds where they need to. This is more a problem with buyers because we have buyers that will wire large amounts of money to an attorney to close a deal. And if if somebody hacks it and they make it look really good that it's coming from that attorney and it's really not, it's going to some offshore bank account and they never see that money again. So you want to just double check. I always have my clients, if they receive a notification of needing to wire money somewhere, I tell them, call me and call the attorney. Because we need to know what's going on there. Additional terms. Not very often do I put anything here. But it just says, if there is a conflict between the terms in this section and any part of this agreement, the terms in this section will control. Firm and buyer also insert see attached and add additional terms with a separate addendum if it doesn't fit here, obviously. Merger, modification, assignment, enforcement, attorney's fees, and governing law. The way I explain this, and I don't read any of this when I'm in front of a buyer, but the way I explain this one is that everything that they sign is the entire agreement. Any changes or modification, assignment, anything like that would need to go through a written approval process of all the parties that are involved in making that decision to either merger, modify, assign, enforce, whatever, okay? Then you have your non-discrimination section there. It used to be bolded, there's just capped now. And then we have our signature page. And that is it for the buyer agency agreement. Okay. We have lost everybody on Zoom.
Oh, you lost your Zoom people.
No. 10 minutes to 2. I wonder if it had a 30-minute time limit or something. I don't think this one does though. It's an office account. Huh. All right.
Thank you.
What else? Any others that you want to look at? Did it help? Okay.
We're going over to Greensboro for Stephen's birthday.
Okay. I already told him happy birthday on Facebook. Somewhere.
It's a good one.
Oh, yeah.
We're out of here.
All right. Thanks for being here, y'all.